Okay, so the California Residential Purchase Agreement is the document which the buyers offer for a seller's California real property. So that's what the form is used for. Every paragraph that's been drafted is to address the situation that can have a consequential impact on the buyer or seller or both. And thus, this material is important. So, as a real estate licensee, you should become familiar with the entire RPA so you can help guide your buyer or seller through what is typically the largest financial transaction that they would possibly would ever have in their life. So, if you look on the RPA, page 1, and the RPA can be used anywhere in California. So the RPA is the appropriate form for condominiums, homes. It's also a form to be used with like mobile homes. You just have to attach the appropriate addendums, because a lot of times agents will say, "Where's a mobile home?" Because it used to be different. You know, you had a separate RPA. It's not like that anymore. You just add the RPA or the addendums that apply. The RPA is sometimes used by real estate licensees for the sale of residential property with 2 to 4 units because it can be. However, another form, which is the RIPA, the Residential Income Property Purchase Agreement, is better suited for those properties because they generally use for income generating purposes, therefore making them more of a commercial in nature. So it's important to, if you are, selling, a duplex, a, triplex, a fourplex, to see what it is that, the best contract to use for your transaction. So getting into the residential purchase agreement. So the first line is one of the most important, and it's the date prepared. And you'd be surprised at how many times it's left blank, but you do not want to leave this blank. This is the date that you are completing the offer. The purpose of this line is to make it easy to refer back to the RPA, because obviously if you do addendums, if you do counters, this date is going to be your reference date on all of those documents. So super important to fill that out. And here is where the identity of the buyers are revealed, where this is an offer from. If there is not enough room to write the names of all buyers, then indicate that additional buyers will be named in the addendum, or by using the CAR form ASA, which is the additional signature addendum. And you can see that in paragraph 32. If one or more of the buyers is an entity, such as a corporation, an LLC, or a trustee of a trust, then identify the entity buyer, not the signing party for the entity in this paragraph. So that's where a lot of people make a mistake. You need to be writing the name of the entity. And obviously there's other forms that you're going to attach. We'll get to that later, but using a shortened version of the name of a trust or trustee is acceptable, provided the full name of the buyer and the legal authorized signer for the buyer is included in the entity buyer paragraph in 32. Okay. And then, so that's buyer. And then the property to be acquired this is the best and most common way to describe the property, that's address. There is spaces there for 2 parcels or more, whatever you could fit there. Sometimes they do have more than one parcel. And 1D, buyer and seller are referred to as parties. So the RPA is an agreement between buyer and seller, not brokers. So whether representing a buyer or a seller or both, a broker is not responsible for parties for compliance with the terms of the RPA, or the refusal or failure of either party to meet one or more of their contractual obligations. So the brokers are referred for the purpose of confirming agency. Okay, so just so you guys know that. And let's see. And then 2B is the confirmation of agency should clearly state the names and licensee numbers for each brokerage firm and sales agents, and also identify who the brokerage firm and salesperson represent in the transaction. Under the law, a salesperson must have the same agency relationship with the buyer or seller client as the brokerage firm. If two salespersons working through the same brokerage, even if one works primarily with the seller and the other works with the buyer, the brokerages is a dual agent representing both buyer and seller. So remember, although let's just say Doris and I are doing a transaction, she's selling agent or seller's agent, I'm buyer's agent, we are a dual agency because we work under RE/MAX champions. So the only time you won't be is some of you guys are champions and RE/MAX champions. We are not dual agency because Jeff is a broker of record for champions. Jennifer is a broker of record for RE/MAX. So we are not dual. Okay. So always make sure that, because I do see that gets confusing because people think, well, I'm helping the seller, not you, but you are considered a dual agency for brokerage purposes. Okay, and 2C, additional brokers. So on occasion, more than one brokerage firm represents a buyer or seller client. Since the agency confirmation paragraph is set up to list only one brokerage firm for a principal, it's necessary to inform the buyer or seller of the name or licensee of another brokerage. So that's in the event there's an additional brokerage. So that would be in the event that, like, me and Tassie work together on a form on a file, then the TC would add that form to show that there's an additional agent. Okay. And potential competing buyers and sellers. So this form, there's a PRBS, and this is a possible representation of more than one buyer or seller form, and it advises the principals of the fact that either broker may represent other buyers or sellers who might compete with them for the property being purchased. So that just, allows you to have another buyer you're talking to or another seller you're talking to about the property. So now, obviously this was changed in 22. I think we started using it at the end of December of 2022. And they refer to it as the grid. And honestly, I think it makes it so easy to use because the first 3 pages are basically the whole thing. Everything else is a reference. You reference to that paragraph or to that item. But everything here is pretty, straightforward. I think that it's important to create templates if you don't have them already in your forms, because it makes it easier to reference instead of rewriting stuff every single time. The items that you're going to continue to write in, they're already set for you. You just use that template. So that's for another class, but just if you don't have templates, I definitely would look into them. If you have templates, make sure that they're up to date because things change too. So that's something you want to, make sure you take a look at. So item 3A, purchase price. This is the price the buyer offers to pay the seller. So it does not include closing costs or any other fees. It's just the price that they're willing to, offer on that property. And if the all cash box is checked in the last column, then the buyer is representing that the buyer does not need to borrow money to purchase the property. And so the following paragraphs will not apply because you don't need to worry about financing. Expiration of offer. The buyer's offer must be accepted by the seller within the allotted time. An attempted acceptance after the allotted time does not automatically create a binding contract, but the buyer has the right to waive the seller's late response and agree to be bound. In such a case, it is preferable to document the mutual agreement to proceed regardless of the untimely attempted acceptance. So in other words, people always ask me that, does it expire in 3 days? It's up to your buyer because you can extend it, okay? Initial deposit. A deposit is not legally required to create a binding contract, but it is usually expected. And again, we already know as buyer's agents, we want to make the offer as appealing as possible to the seller, but always keep in mind that that's your client's money you're putting on the line. So now that before it was 10,000 small claims, now it's 12,500. So try to keep it below that because, God forbid you have to go to court. You can go to small claims, with that amount. So you always want to keep that in mind to try not to go above the allotted amount in case you end up in small claims. So let's see. And obviously the money isn't sent until offer is accepted, and then the escrow contacts the buyer. Usually within 3 business days, the money is wired, or that can be negotiated. I know on our contracts we do 48 hours from acceptance, so because we want that money in there as soon as possible. They shouldn't need 3 days, right? And increased deposit. A buyer may be asked to place more money in escrow after the initial deposit. I see this happening when you get an offer from someone who has money in a 401k, who has money in some type of retirement or stocks or bonds or somewhere else other than, easily accessible. So when this happens, they say, I only have $1,000, but they really wanted this house, but it's going to take us 10 days to get the other money. So you as a listing agent or as a buyer's agent can decide to put an increased deposit, and then specify how much and by when that money has to be inputted. If you notice to the additional terms, it is upon removal of all contingencies as well. Sometimes people want to wait until they do an inspection to even make sure that they're going to move forward. So loan amount, which is E1. The RPA requires specific details of the financing terms to be identified, or the contract could be considered unenforceable. So on 3E1, address a loan which will be secured by a first lien. Unlike the initial and increased deposit, if the purchase price changes through the counter offer process, the loan amount shall be in the same percentage to the final purchase price as being specified in the RPA. A buyer should specify the maximum amount for a fixed or adjustable rate that the buyer is willing to pay, because if the buyer's chosen lender will not offer the buyer a rate at or below that specified price, the buyer will have the contractual right to cancel during the loan contingency period. The buyer also needs to identify if the buyer is agreeing to pay any points to obtain the specified loan at the identified rate. If the buyer plans to seek a loan through the FHA or VA program, or seller financing, or some other different type of loan, that should be specified in this column. If the buyer is seeking FHA or VA loan before a lender is authorized to loan funds pursuant to these programs, the property must meet certain condition, and therefore it may be necessary that certain repairs be done to the property. So buyers must be aware of that. So there's additional forms that are attached. Obviously, if you hit FHA or VA, you get the FVAC and the HID form. So those are to making sure that the property appraises. And then, like you mentioned, it's whatever the appraiser says, if there's like any conditions, they call something out, then that's something that has to be addressed. So does anyone have any questions about that? No. And per ROD, just so you guys know, that loan information is really important, especially if you're canceling at the very end because of not qualifying for a loan. That really is an important section to fill out. A lot of people don't really pay attention to it, but it's definitely important. Yes.
They don't get approved for the rate that they want for the loan, and they cancel, do they lose that deposit?
Not if their loan contingency is in place. Yeah. But the thing about and I'm sure those of you that have been in contracts know that although this is written a certain way, not every agent interprets it the same way, and not everyone abides by it the same way. People make up rules as they go along, right? So it's important to definitely try to remain professional with the other person, because the last thing you want is to be, as Pam's word was, flex. Everyone wants to flex when they're in escrow. So it's important, to have that, because I think they're a little bit easier to work with. But I know there's times when they're not easy to work with. Believe me, I know. 3E2, additional financed amounts. So as with the first loan identified in 3E1, the interest rate on the loan and the amount of points the buyer is willing to pay, all that, like I said, is important. Especially right now with rates, kind of fluctuating and stuff. You definitely want to protect your clients. That way, if they do have to cancel, it's like, look, this was the only loan they could get, and it's at 7%. We said that they would be at 6%. Obviously, they can close if they're comfortable, but that protects them, so. And you'll be surprised. Some listing agents will want you to take that interest rate out. They'll tell you, we don't want you to put that in there. So I've seen that happen too, because they know. So the occupancy type. Okay.
So you're saying that if they put in like the 6%, but they got the 7% loan, this, and they do fall out of escrow for some odd reason at the end, they're not contracted.
Right. Exactly, because the seller has agreed that they're going to get that type of financing. Yeah, if the loan contingency. I mean, you could still fight after because maybe they thought this or that, but I mean, it's a fine line. So just always make sure before you release loan contingency that you're ready to release loan contingency. Make sure you have that understanding. That's why, again, relationships are important, that you work closely with your lender, you trust your lender, and that they tell you, yes, you're good to go, then you're good to go. The occupancy type. So the buyer's use of the property will determine the type of loan and interest rate that a lender is willing to offer. So this is important for you to mark if they're going to live in it. It's going to be their secondary home or investment. And then the balance of down payment is going to, whatever loan amount you put in there, and between the down payment or the EMD, that's all going to calculate for you. And then the total purchase price is the same amount as the that they're willing to pay for the house. So then if you go to page 2, so in this paragraph, the amount the seller agrees to pay should be a dollar amount. The percentage calculation in the 4th column is for informational purposes only. So you just type in the dollar amount and then it calculates. The amount the seller agrees to pay will not vary if the purchase price changes during negotiations. That's why they want a dollar amount and not a percentage, if you notice that. So make sure if your client needs 3%, just know that. That's how it works. If the price changes, then it may be less than what you're asking. The credit must be applied to the buyer's closing costs only, unless otherwise specified in the last column. Okay, an additional finance term. So any other term that potentially affects the financing of the purchase, but not the price, would be specified here. Okay, so any other term. And 3H1, verification of all cash. So the proof of sufficient funds must be attached to the offer unless the box is checked for the proof to be provided after the offer has been accepted, and with whichever amount of days is accepted. Same thing with the verification of down payment and closing costs should be attached. If it's not checked, then obviously it is attached, which most likely it should be. And verification of loan application, same thing. And then you would mark, are they pre-qualified, pre-approved, or fully underwritten? If you ask your lender that question. And they should have one in there they just did a phone call. They don't have any documents. I've seen that happen a lot. So 3J, a final verification of condition. So the RPA allows a buyer some time prior to the close of escrow to examine the property and to make sure that the seller has made all agreed upon repairs and requests and other contractual responsibilities, that the property is otherwise in the same condition it was in on the date of acceptance. If the buyer discovers any discrepancies, the contract should be looked at for potential remedies. So we all know that, and this is, per Rod, a final verification is not a contingency of closing. A final verification is just like exactly as it says, to verify that the repairs were done, to their acceptance. Now, it can get tricky. I've had a lot of issues when it comes to this. So I'll give you an example. I did a final walkthrough with my clients, and the pool was green. It was no longer blue. So I took pictures, I sent it to the agent, and I'm like, hey, just to let you know, this pool was not like this. I called a pool company, I sent pictures, they gave me an estimate. It was going to be about $800 because now they had to drain it. They could not, bless you, they could not just simply, shock it or whatever. It was beyond. So I think it was like $800, something like that. So I told them it's going to be $800, and he's like, well, don't hold up escrow for closing for that, right? And I said, okay, well then let me call escrow and have a hold for your seller of $800 because the seller wanted to come out and try to shock it, right? But I told him if that's not acceptable to my clients, then that $800 is going to go to my clients. So that's what we agreed to do. So we didn't hold up escrow. Now I know there's agents who will hold up escrow, and which is not the right thing to do. If you're not sure, if you have issues, talk to one of us and we'll guide you on what's the best way to go about it. Sometimes it's bad. You go and you're like, whoa, wait, what? This is not repaired, but again, think about this. When you're negotiating your request for repairs, think about this. And I try to tell my clients, I rather them get a credit. And the reason why is because most of the time a seller is going to try to do it the most inexpensive way possible. And they can, because you're just saying fix it. So you don't want to have those issues later. So in my opinion, go for the credit. That way they can deal with it however they please once they close. They got the money. And if they hire the wrong person, guess what? They hired the wrong person. It has nothing to do with your transaction. So that's my advice when it comes to that. That way you're doing your walkthrough and you're like, yeah, you knew that, and you were good. So we're good, and you just keep it moving, right? Okay, so the assignment request. So the buyer is given the right to assign the contract to a third party with the seller's consent. This doesn't happen often at all, but sometimes it does. So, but seller is under no obligation to consider the assignment if it's made after the 17th day. So loan contingencies, here we get into our favorite, right? Contingencies. So the loan contingency may or may be waived or removed at the time of, the offer or specified date. But it's important to make sure when you're writing the offer, or if you're a listing agent reading the offer, if you want to counter, make sure that you're giving them a fair amount of time. So that way you're not like, oh, they're willing to close, take it in 10 days, but can they really? Because then now you're having issues, so talk to the lender or do whatever you need to do to see if it is actually possible, because now you're setting up expectations, with your sellers or your buyers or whatever, or if you're the buyer's agent, you're putting them in a bad position in case they're not able to meet that. Yeah.
For contingencies, do days start counting once you open escrow or when you get your offer?
Acceptance. Yeah, so if you notice, it says 17 days after acceptance. Yeah, so as soon as it's accepted, that's day 0, tomorrow's day 1. Okay. And appraisal contingency, same thing. The appraisal contingency applies whether the buyer is making an all-cash offer for the property or needs a loan. So don't assume, oh, it's cash, there's no appraisal. They still have to send you a contingency removal if it's all cash, because sometimes buyers want to verify the value as well, that that are paying cash. So make sure you're aware of that. And same thing, this contingency can be removed or waived, by simply checking the box in the last column. The default position is that the property must appraise at the value of the purchase price, but that can be changed by checking the box and inserting a different value into the third column. Okay, so if the buyer is making an offer with the intent to finance through FHA or VA, regardless of when the appraisal contingency is removed, the buyer's offer is contingent upon, them providing the FHA or VA lender with the proof of what the value is. So if you guys see there, let's see. On appraisal, it says, if you notice in the box, it does say appraisal contingency based upon appraised value at minimum of purchase price, or you can put a price there. So if your client's willing to pay above, you know, like, let's just say it comes in lower. Let's say you offer 500, but let's say you say, you know what, I'll pay 505 or 495 or whatever the case is. You can put a different amount in there if you wanted to. Investigation of property. So the contingency allows the buyer to conduct and hire others to perform inspections. So this can be every type of inspection possible. Termite, you know, your regular home inspector, or you can hire sometimes people will hire, you know, each trade. So they'll hire a roofer, an electrical, a plumber, you know, whatever your client is wanting. This is the time for them to go in there, to have the right to enter, to do any and all inspections needed during this time. This is their discovery period. Okay, and then obviously you want to make sure that when you're waiving your contingencies, that if you're waiving everything in the inspection, make sure you look at it, because they changed that form. So you want to make sure you've already received, if you're, you know, let's say there's solar, or let's say there's other things that you still haven't received from the seller, you want to make sure. So pay attention to that contingency as well, because a lot of people are still marking everything, but they don't mean, then they tell me, oh, I didn't mean everything. I meant everything on the inspection, which there is a box for that, but they're just so used to the old school where it was just so simple. Now it's broken down a lot more. And then informational access. So the buyer's right to access the property for informational purposes is not a contingency. So you can put, if you want longer time there than your inspection of the property. Usually we keep it the same, but that's up to you if you want to do that. Review of seller documents contingency. So the contingency allows the buyer to review all of the disclosures, documents provided by the seller, and based upon the review, cancel the contract if they're not satisfied with whatever the property is revealing. If the seller does not deliver all documents on time, buyer has 5 days to review late delivered documents. So let's just say, for instance, it says 17 days, but let's just say you don't get it till day 25. It happens. You know, it doesn't mean that the contingency is gone and you don't have, you know, you can no longer review them. You have 5 days after that. So again, when you get them, that's day 0. The next day is day 1. Okay. And that's why.
Let's say you got all the disclosures except the avid from the sellers, right? You're the buyer's agent. So now you get the avid 3 days before closing. Do they still have 5 days because it's a disclosure?
Yes. So agents, get your avid out ASAP, because that's another reason for them to cancel. Imagine you being listing agent, turning in your avid at the very end. They've already, even if they removed contingencies, but you turn in a late document, that reopens that up for them to cancel. So now the likelihood of them canceling is probably unlikely, but if they wanted an out, they have it. And now you have to tell your client, oh, well, you know, I failed to do my part. So, you know, you don't want to do that. So you definitely want to do your avid. If you're a listing agent, I try to do it as soon as possible, whether it be at the listing appointment itself, or even when I like to show up for the photos. I want to get it out ASAP, because that's part of your disclosures that you want to send to the buyer as soon as possible. I mean, obviously, if the house is in good condition, you shouldn't have to worry about it, but still, there's still things on that avid that are important. So let's see. So preliminary title report, same thing. As a listing agent, I order everything at the minute I take that listing, because I want to know if there's any issues. Don't wait to order it when you open escrow, because you could have problems that you marketed this property for a month or 2 months and had no idea about. So you want to definitely order your prelim as soon as you take the listing. That way it gives you time to review it with your seller. Make sure there's no issues. You'll be surprised. Some people are like, I didn't know my cousin, someone, whatever is on title. I don't have no idea where they're at. Or there's issues with liens that they didn't know about. So you just want to make sure that you have taken care of all that, so that way you can close and everyone's happy. And as a buyer's agent, when you get the preliminary title report, definitely important to review it. Make sure there's nothing on there that they need to be concerned about. and go from there. Sometimes people don't realize they have easements on their properties. So this is something, definitely you want to review it with your clients to make sure that they're aware of everything that's on there. Common interest disclosures. So this would be like HOA. So you want to make sure that you receive all of the, everything, not just a portion or an old disclosures. Because some sellers are like, well, I still have mine when I bought it 3 years ago. Those don't count anymore. Things changed. So you want to make sure you're ordering your HOA on time and you're receiving it on time to give your clients enough time to review those documents. Review of leased and lien items, same thing. If the client has solar, water softeners, alarms, cameras, there's a lot of stuff that can be leased. You want to know, what you're signing up for, what you're taking over. Sale of buyer's property. The purchase contract is not contingent on the buyer's ability to sell the buyer's existing property unless this box is checked. It's important to check this. If your buyer is selling a property, if it's an escrow or whatever the case is, if your client needs to sell, if they can't qualify without this, it's important to have it, just so that way it protects your client. Time of possession. Another important clause. Seller shall deliver possession to the buyer, including keys and means to access all areas of the property when notified that the deed from the seller to the buyer has been recorded. The timing can be made more specific by checking, the applicable boxes. It usually defaults to 6 p.m. And the property, if the property seller occupied, vacant, or tenant occupied. So this M is so important because in the beginning, a buyer a lot of times is just excited and they'll give the seller 2 weeks. I'll give you 2 weeks to get out just because we want the house and we don't care. But they don't complete the, either the seller in possession form or, whichever form is applicable. And they just leave it at this. But then when it comes time to closing is when when am I getting my keys? I'm excited to get my keys. Wait, they're staying in the house? Wait, I just signed escrow docs. I have to pay interest every day. Wait, for free? Like what? So it's important to make sure you fill out that form so they understand, because then you have issues when it closes. Now everybody's not in agreement. You see what I'm saying? So it's important to add those forms and so everybody's happy.
I can add one form addendum saying, write it, and then when they received the funds, I said, hey, we need the keys, and I sent it back, I said, remember what you signed, it's 2 days after. And then the agent called me and said, remember, you signed, yeah, with the client. All my clients wants the key. No, it's right there, write it. And then 2 days after, I was calling in the morning at 7 a.m. I said, 2 days, it's 2 days, maybe tomorrow at 7 a.m., whatever, but you keep calm.
Yeah. Yes.
If I didn't have that.
Yeah, it's super important. And I know Arlene had an issue with one too, where it's in the counter, I think it just said seller to remain in possession for, I don't know, a week or something, or 2 weeks. So buyers interpret it one way, sellers interpret it a different way. And so again, at the end, everybody's arguing about what it really meant. So that's the purpose of those forms. So anytime you check something, make sure that you're including the addendum that goes with it, so that way it breaks it down. Now, just as a courtesy, typically we give 3 days after close for a seller to go, because we do understand we don't know the exact day it's going to close. So that gives them a little bit of time to maybe schedule, a moving truck or whatever the case is. But if they're going to stay in the property for more than, 15, 20 days, I definitely usually will, and even if I'm the listing agent, buyer or listing, I'll usually hold a deposit in escrow. And the reason I do that is because, what they say, when you're under stress and pressure is when you find out who you're really working with, right? So you want to be sure that if it's your buyer, they have $1,000 or $1,500 in escrow, because they want to make sure that that the house is going to be delivered in the right fashion, right? So the seller. So whether I'm helping the seller or I'm helping the buyer, if I'm the buyer's agent, then I'm going to tell the listing agent, your client can stay in there, but I want $1,500 held in escrow, because if I have to throw away trash, if I have to do anything to that property, who the buyer's going to expect who to do it? Me, right? And it's not my responsibility. And you try to call the agent, they're done. Like, that's your problem. So you have to learn how to protect yourself. And that's the biggest thing, I think, after filling so many out, you learn. And then if I'm the listing agent, I tell my seller, I set up the expectation. If you guys are going to plan to stay here, then you have to leave a deposit in there, because it's just to make sure you get, but we're going to leave it clean. So I understand, and I know you are, so you'll get your deposit back, but it's important you leave it in there. And again, same thing, because I had that happen where my seller, who I never in a million years thought she would do that, left 2 mattresses thrown in the driveway. So thankfully, she called and, took care of it, but I just don't want to go through that. And I wouldn't want anyone to do that to me. So that's the purpose of that. So make sure you're doing that. And then if it's a tenant in the property, you definitely want to include the TOPA form. You definitely want to, because you want to have an understanding on those tenants when they are either leaving, or if you're accepting the tenants, that's fine. But that form is super important to include. Don't just take their word for it. Seller delivery of documents. So paragraph 3L4 gives buyer a contingency for review of the seller's documents. So this paragraph sets the time for the seller to deliver the required documents. So it's defaulted to 7 days. But if you have a quick escrow, maybe you can default it to 3 days, or whatever the case is. We'd like to receive it obviously as soon as possible, because the sooner we know if they were going to move forward, the better. 3 and 2, sign and return escrow holder instructions. So both the buyer and seller are contractually bound to sign escrow instructions and return them to escrow within 5 days of receipt. So that's after they received it. So if they received it on day 10 of the acceptance, then obviously by day 15 they have to send those documents back. So they have 5 days to send those back. And so installation of smoke detectors, carbon monoxide, and water heater bracing. So the obligation to take care of the smoke alarms, carbon monoxide, and water heater is both a state and local mandate. The work needs to be accomplished within 7 days after acceptance, so the buyer has adequate time, obviously, to order their appraisal. So this is something, again, as a listing agent, you should check when you're sitting with your client to sign the listing. Make sure that they do have working smoke alarms in each bedroom, in the hallway upstairs and downstairs, and a carbon monoxide detector, 1 in the hallway if it's single story, or 2 if it's 2-story. So you want to make sure that that's done. Go take a look at the water heater bracing. Make sure it's secure and tight. Make sure that, because a lot of times people, they move it, they don't realize the importance of it. So just take a picture of it. If you're not sure, you could send it to your home inspector or whoever and say, how does this look to you? Just being proactive is super important. And evidence of representative authority. So if the buyer or seller is an entity, the person signing for the entity needs to provide proof of authority to sign. So that's within 3 days of acceptance. But typically, if you are writing an offer, you should be asking for that paperwork ahead of time, because you, again, don't want to waste your time. You want to know that they are the right person who has the authority to be signing those documents. Okay, so item 3P1 is items included. So this part is super important too. When you are with your client and you're looking at 2, 3, 4 homes, if your client makes a comment, or if you see something that maybe is, you're even wondering, I wonder if this is going to be part of the sale or not. It doesn't say nothing in the MLS. And you might think like, wow, they wouldn't leave this with this property. You can take a picture of it just so it reminds you when you are going down to sit down to write the offer. You can go back to your notes and say, hey, this is the house that had that, chandelier or that some unit or something. And I'm just curious if it's included or not. because you, like, again, it's important to set up the expectation to your client and have that understanding instead of, later on, hey, I thought when you do your final walkthrough, it's removed. And so then it becomes a battle. So, fixtures become part of a real property and are transferred with it. To avoid disputes, if some items are intended to be included, there's 16, they pre-printed items that were most common, that people would disagree on. So that's why they pre-printed them for us to make it easier. And only one of those items is bathroom mirrors that's pre-checked, because though if there's anything hanging on the wall, it stays. Okay. Because people change the mirrors now. It's not like old school where they were glued. Now people put fancy mirrors up. So definitely a question to ask your sellers, and then obviously your buyer. So if you're not sure, you can mark it. A lot of times your clients will say, I want the stove. Oh, I like their dishwasher or their washer and dryer, or, some clients want the spa that's outside, or they want the kids playground, or, I've seen people like, oh, I like their fountain in the front, just whatever. Just make sure you put it on there. And then also excluded items. There may be items where the seller may intend to leave, because maybe in the MLS it says seller's going to leave certain things, and your client's like, I don't want their trash, basically. So you can put that in excluded items and make sure that you do document that. And then, just for clarification, even if it says in the MLS something staying and you didn't request it, the contract is what's binding, not the MLS. So a lot of times agents are like, well, it was there, so I didn't think I had to put it here. No, you always want to make sure that they acknowledge and sign it, because this is what they're going to go off of.
After close of escrow, the seller moves out, the buyer moves in, and say the seller left the microwave or something like that. At that point, the seller can get rid of those items.
You mean the seller, like,
The buyer can get rid of those items.
if they don't want them?
Well, I mean, they had just left them behind.
Yeah, I mean, what I would probably do is I would call the agent and say, hey, just as a courtesy, these items were left. They're going to dump them. If they want them, then let me know, within the end of the day or whatever. If it's important to them, they're going to tell you. If it's not, then yeah, I would just do that just as a courtesy. And so then, so items included and excluded. And so paragraph 3Q, allocation of costs. So here, this just breaks down, who's paying for what and how it's broken down. So your natural hazard report. So the RPA requires the third party report to address, one of the non-natural hazard items. So here is where you're going to mark who's paying for it, buyer, seller. Typically, seller pays for the NHD report. And then you can put provided by, if there's a particular, company that you use. Do you want it to be environmental or other? And then 3Q2, other reports. These are the paragraphs to list other reports that the buyer or seller wants provided as a part of the transaction. So this is where you could put termite. Obviously, if you're going to include septic, you want to attach that, and we'll get to that page. You don't want to put septic here, because there's an addendum that should be attached. But I do see people put it here, where they'll put septic inspection, and then you're in escrow and they're like, I need the septic certification, I need it dumped. I'm like, no, you didn't send me that document. You just send me for an inspection. So be sure that you're adding the right forms to your contracts, so that way it's a clear picture as to what the expectations are of each party. So that's where you would put that. If, let's say, the roof looked bad, you can ask for, a roof report, something, anything, anything goes there. Any other type of report would go there. Smoke alarms, carbon monoxide detectors, and water heater bracing. So this is in the event it's not done, who's paying for it. Q5 and Q6. So this is typically like in LA, right? You have your city inspections before and after. So I always go by what Rod had always said on these particular, and I never check them. I leave them blank, because he says that if they are marked, you are blindly accepting the responsibility of any repairs that are needed without knowing what's needed. So this is something, because I've had agents that call me and say, oh, well, I'll counter it out because everyone puts it in there. And if I'm the listing agent, I counter it out. And they're like, your seller doesn't want to pay for, repairs. No, that's not what that means. That means that we can negotiate. But if we mark this, then that means my seller's obligated to pay for that. But I don't want to obligate them without knowing what their obligation is. So I always try to keep that blank. So as a listing agent, you want to make sure if you get an offer that's marked that, you counter that out. Okay. Yeah.
Does it refer to all homes or the homes that need permitting?
It depends. I do it all just across the board because you don't know. There could be a city mandate, there could be a county, you just don't know. So I just make it a habit for everything. Even though it's more in LA County. And escrow fees, if typically we mark each to pay their own because the seller has their fees, the buyer has their fees. There's some buyers that want their offer accepted and they want to appeal to the buyer or to the seller. So then they'll mark that they'll pay for both. They'll pay, both sides. Owner's title insurance policy. A title policy assures that the buyer that if the title is not as promised by the title company, the company will defend challenges to the title by others and compensate the owner up to the value of the policy. So this is important to mark. Usually seller pays for a title policy when they transfer their home. And then you can write who you want in the title, seller's choice or the name of your, title company. Buyer's lender title policy. While an owner's policy protects the buyer from title issues, it does not protect the buyer's lender from title issues. So that's why the lenders insist that the buyer pay for a title policy to specifically protect the lender's interests. Okay, so obviously if they're paying cash, they wouldn't have a buyer's lending policy. County and city transfer taxes. So the county transfer tax is 0.55 per 500. So half of that fee goes to the county and the other half goes to the city, unless the city has a separate transfer fee, which case the county keeps the entire amount. The city transfer tax or fee is set by the city. So if you're unsure, then just then mark both Q10 and Q11 as seller. Because if you're not sure what city has their special tax, you can always, select that so it protects you. Q12, HOA disclosure preparation fees. So we already know that the HOAs charge for them to prepare the packet to get sent to escrow to review by the buyer. So they automatically defaulted that where it wasn't that before, which is great. So the preparing disclosures are paid for by the seller. The HOA cert fee by the buyer. And then Q14 HOA transfer fees, that is negotiable. So you can decide, who pays for that. And then the private transfer fee is a charge that often is forwarded of some kind of nonprofit organization or other entity that does not necessarily benefit the property or the HOA. These fees must be recorded in a separate document, not just inserted into lengthy like CC&Rs. Many HOAs charge additional fees and call those fees by different names. An example is a community enhancement fee. These type of additional HOA fees can be written into paragraph 16 or 17 if there's additional fees. Have you guys ever seen that where it says, I know like where I've seen it the most is in, I want to say it's Lake Elsinore and Corona, where their particular HOA has a enhancement fee and it's like $1,500, like in order for the buyer to join that HOA. Have you seen that? Like, and it'll say in the agents that know that it's there, some agents don't know. And then once escrow gets the HOA docs, there's the breakdown of fees, and now the buyer has an additional fee. So some of the agents will put, buyer enhancement fee to be paid by buyer. And so it'll say how much it is. So just so you guys know, be aware of that, especially if it's an association. Maybe you can ask, do you know if there's an enhancement fee with this property? Because that your buyer, would appreciate to know that up front. Or you could simply mark seller, or it actually is already marked off by seller. So if that comes up, unless they disclose it or they put it on the counter, then that can offset that. Since not all items that result in a charge to the buyer or seller can be covered in a standard agreement, additional paragraphs have been provided. So that's what the Q16 and 17 are. So like if you have an administrative fee, a TC fee, or any other type of fee, that's where that would go there. Home warranty plan chosen by buyer coverage includes, but it's not limited to. So here is where you would write in who's paying for the home warranty, or are they waiving the home warranty? And if the seller or both check seller's cost not to exceed. So how much, are you asking then, and what company are you asking? And 3R, additional terms. These terms are related to financing, but which do not alter the purchase price, so should be listed in paragraph 3G2. However, if the term is for a seller credit to cover buyer's closing, then that should be addressed above, like we mentioned or the prior page at 3G1. Any other term should be specified in 3R. If there is not enough room, then it will create a TOA, which will take your language, to another addendum. So terms here could be, maybe if there is a pool, I would specify if, you want, like a lot of times I'll say, pool to be, maintained, because even though the property should be delivered in same condition, people just forget about the maintenance. They start canceling all their gardening and everything else. So I always put that there so that way it's specific to it. If they have a lot of stuff on the property, all their personal property to be removed, because again, people think, oh, but the buyer might like that. Oh, the buyer might want my old paint that's been sitting there for I don't know how long. They just, they do those things. So it just kind of helps save the headache. And property addenda and advisories. So here is, again, the importance of this is where you want to attach any addendum that applies. So like we mentioned, if it's tenant owned, you definitely want to attach that. If it's in probate, manufactured home, if the title is held in tenancy in common, if it's a stock cooperative purchase, mixed use purchase addendum, and other addendums. So anything that is important, court confirmation, short sale, a septic. Here is the septic backup offer addendum. In the event that they tell you you can be backup, you want to send that as well. And then the buyer and seller advisories. So here is where you're going to take a look and see if you're located in a wild disaster, area, to include those. Any other type of advisory is where you definitely want to include those. So that is basically the grid, like I mentioned, that you have to fill out. From 5 on, it gets a little bit deeper. And I think we could probably have another, because that's already 12:15. I didn't realize. So we could probably get into that deeper. But what I do want to just show you really quick is if you go to the last page where, let's see, is it? So on page 13 at the bottom, time is of the essence, and then the terms and conditions of this offer. So this offer to purchase a property, on the terms and conditions, everything is spelled out here, everything. So if at least one, but not all parties initial, a counter offer is required until agreement is reached. If they accept this offer the way it is, but the wife signs it today and the husband doesn't sign it till Friday, then the actual acceptance is Friday. It's the last, it's the day that it was last, signed by the final party. So make sure that you guys are aware of that. Timing being of the essence. All understandings between parties are incorporated in this agreement. So if the agent calls you and says, hey, well, my seller said they'll do this. Okay, well, incorporate it into something, an addendum or whatever you need to do, because things change. As you start dancing, the rhythm changes, right? So you don't want to be left on the dance floor alone. That was page 13. Yeah. And then the liquidated damages clause. This is important, especially, well, if you're a buyer's agent, it's not, because you don't want them to keep your deposit. But if you're a seller's agent, you want to make sure that this is initialed. That liquidated damage clause is definitely initialed, because sometimes they'll try not to initial that. The liquidated damage clause? Yeah, so basically, a liquidated damage clause allows the parties to predetermine what the damages will be in the event the buyer is in breach of contract. So generally, these clauses permit the seller to keep the buyer's deposit. The clause must be separately signed or initialed and appear, well, like how it is. So everyone has to initial. And it's important to remember that the liquidated damage clause specifies the dollar amount the seller is entitled to. It does not authorize the automatic release to the seller. The seller still has to prove the buyer breached the contract and did not have a valid contractual reason to cancel. So according to the release of funds, will require further written agreement, from both parties, or a judicial decision or arbitration award. So this clause to be included as an obligation under this contract, it must be initialed by both. So basically, it just says that here, if the buyer fails to complete the purchase, and if the property is a dwelling with no more than 4 units, one of which buyer intends to occupy, so there's certain things that have to be met, then the amount retained shall be no more than 3% of the purchase price. So if the price that you're in escrow for is $500,000, the max a seller can take is 15. It can sue up to 15,000 for them not, for them breaching the contract, basically. Yeah. So if they have 25,000 in escrow, you can't keep it all. You can only keep 15. So there's that. And then at the make sure that if you are countering, that you are checking the seller counter offer. A lot of people don't check that. They forget that they're countering. So you want to remember to always 33A, make sure if you're countering, and then if there's an entity for the sellers, make sure you're writing that. And make sure you have all of your buyer's brokerage or seller's brokerage information filled out completely as well. That's super important. And yeah, I think that's it for today. Like I said, there's so much we could. The last time I did it, I think we did it in 3 classes, because it's a lot. It's a lot of information. But do you guys have any questions? I can show you. Yeah. Yeah.